Welcome you all to lecture number 7 of Criminal Law Basics Concept. This is Clat lecture series sponsored by Sri Jendra Engson. I am your mentor, Shekhar Gehlot. So now we are continuing with the right to private defense and we are on the end part of the right to private defense. Now we have discussed till now right to private defense in relation to person. Person means my body and somebody else's person means somebody else's body. Okay, somebody else's physical being and my physical being. What is the right to private defense for that? Okay, until what extent you can exercise your right to private defense. Now, section 103 is deals with right to private defense in relation to property. It says right to private defense to property extends to causing death. That means in order to protect your property as well or somebody else's property as well, one can cause death. Okay, you can kill someone in your right to defend your property. Okay, and only in these cases, but only in these cases: robbery, breaking at night means someone is trying to enter, commit theft or robbery in night at your house. Mischief by fire on any building or human dwelling, someone has committed a mischief and put some building on fire. Theft, mischief, or house trespass. Okay, in these cases, one can use their right to private defense and can cause death. Suppose I am in my house with my family around 2 o'clock in the night. I hear some noises. I go to check. I see there are three people, three people who are trying to enter into my house. Okay, and two have already entered, and they have knives in their house, knives in their hands. Now, in such case, definitely, if I have a gun with me, I can shoot them and I can kill them because it's a very imminent threat. It's an immediate threat. Robbers are right on my face. They are in my house. It's hours of the night. I cannot expect any public help, and I am the only one savior of my house and family. And they are armed. They are five in number. And if not done something immediately, definitely situation is going to be very poor for my family. So in that situation, without thinking anything about the law, I can straight away shoot those robbers. If one of two of them are killed and other escape, then there is no offense at all. Okay, there is no offense at all. But it also depends upon situation to situation. Okay, it is not that someone is trying to run away with your mobile phone that you will kill him. Okay, someone has stolen my mobile phone and he's running. I cannot simply kill him. Okay, I can chase him, I can beat him, but I cannot kill him. Okay, because my mobile can be tracked by the police. I can register a complaint, and mobile, the value of the mobile is not as much as of a life. Okay, if threat is to your property is such in nature, okay, that it would ultimately cause you irreparable damage. Okay, okay, otherwise other injury would be sufficient. Someone is trying to run away with my mobile. Okay, I gave you an
It's
example.
9 o'clock.
I cannot shoot the person dead. I can definitely shoot him in the foot, maybe. Okay, or I can chase him, I can beat him, I can do anything, but I can definitely not kill him. And in what case I can kill someone, I just explained you. The situation you must be able to imagine it, okay? How difficult that situation could be. Or suppose there is trespass. Some 3 4 people of the society have illegally entered my house. They are hurling abuses. They are threatening me that we will beat you. Okay, now in that case, because they are society people, I have no such fear of death. I can keep my doors locked and I can call the police. If I go out of my house, if I go out of my room and start shooting them, then that will not be a justifiable right of private defense for protection of property. Okay, because some society people have some grudge against me over a parking issue or some issue. Three, four people have come inside my house without invitation and they are threatening me that we will beat you. I simply take a gun and shoot them and then say Section 103 protects me and says you can kill when there is illegal house trespass. No, it is not to be read like this. It all depends on situation to situation basis. Definitely, I can use some force to throw them out of my house. I can use a reasonable force. Okay, force is supposed to be reasonable all the time. Force used must always be reasonable. Okay, it cannot be disproportionate. If act not under section 103, one can cause any harm other than death. Voluntary causing of death extends to restricts. Death extends to restricts under section 1999. If there is any other act to your property which is not covered in section 103, then you cannot cause death. Okay, right to death is restricted under section 99 only. Okay, we have done it. Right to private defense till there is reasonable apprehension of danger to the property, not after that. Like we discussed in the case of personal body as well. If someone has beaten me and he is now leaving, now I cannot chase him and kill him. Okay, right to private defense is not a right to revenge. We don't have a right to revenge. If someone is committing a threat to my property, he says, I'll burn your car. And I stand and keep watching, and he has burned my car. And later, on, after my car is burned down, I go to his house and beat him. Okay, that will not be a right to private defense. That will be an aggression on my part. That will be a crime committed by me. Right to private defense against assault with apprehension to death could run the risk of harm to innocent people. Okay, right to private defense. When you are exercising your right to private defense, against what? Against assault with apprehension of death. When there is such level of assault on you that you apprehend that I may be killed and you exercise your right to private defense, then it could lead to harm to innocent people as well. And there will be no offense. That means. If we are faced with imminent threat of death, okay, if someone is faced with imminent threat of death, that if I don't do anything, other person will kill me right now, then in that case, you can use your right to private defense and can kill the other person. But in meanwhile, in defending yourself, if some harm is caused to innocent people, even if innocent people are dead because of your actions to defend yourself, that will be perfectly okay. There is nothing illegal even if some innocent people are killed in order to defend your own person when you are faced with imminent death and see no other opportunity. A is attacked by a mob with an attempt to murder him. He cannot exercise private defense unless he fires. Many innocents in the mob could die. A commits no offense by doing so. Okay, A is attacked by a mob. Now you must have seen recently a lot of mob issues. Now a mob means a people of 10, 20, 30 people are there. They have gone to attack him. Now when a mob is going to attack you, it is very much apprehensive that you may die as well because mob has no face. Anyone will beat you with anything he has in the hand. though none of them individually has any intention of killing you, and many of them may not be having any intention of even beating you. Many of them may be joining the mob because they are angry with you, but they may not be feeling like beating you. They may be angry with you, and they have joined the mob because they are angry and they want to complain. And some three, four, five people must be ahead of the mob. They say that let us see, we will beat him. Okay, and some people may be only there for just watching the drama. But now they all appear like a mob. 30 people are knocking at the door. What would A do? If A opens the door, the mob is going to kill him definitely. He is having a genuine apprehension. Mob is saying, we'll not leave you alone. We'll not leave you today. Then he has a revolver with him. He cannot escape death without shooting. So he shoots. He shoots in the mob to dissipate the mob. Okay, he shoots twice. Now, on those two shots, two people who are part of the mob, they die, and the rest of the mob runs away. Now, in this case, there can be no offense against this person. These two people may be utterly innocent, totally, completely innocent, may not be even a part of the mob, maybe just standing nearby the drama, just to watch it. Then also he can kill them, and that won't be any offense. Okay, there will be no offense at all, because in such situation you cannot expect, you cannot take care of innocent people, who is innocent or who is not. You will just take care of yourself, and that is the basic human instinct. Let us do some case readings for the private defense. Vishwanath versus State of UP. X and her husband Gopal stayed at the house of her parental house after marriage. Okay, that means X, she is married to Gopal. They are staying at X's house, X's father's house. Okay, X and her husband Gopal, they are staying at X's father's house. Her father and husband were not on good terms. X's father and Gopal, her husband, they are not on good terms. They are daily fighting. Gopal shifted to the matrimonial house of his sister. What Gopal did, Gopal left this house and shifted to his sister's place. Okay, his sister's place, and leaves X there only. His wife is left at her father's place, and Gopal has shifted to his sister's place. One day Gopal came back and forced his wife to get out of parental house and move with him to another house. Now one day what Gopal did, Gopal along with two to three people came to the house where X, his wife, was living. He dragged her wife out of the house and said, you must come with me and you must live with me. Okay, a fight started there. Now, father said to his son that beat Gopal, not kill Gopal. Father said beat Gopal. Okay, it was a Hindi interaction in which son says, Father, Gopal is dragging sister away. Father said, तो मारो उसको, तो मारो उसको. This is Hindi. It means then beat him. But maro in Hindi also means killing. Maro in Hindi also means killing. Okay. Then in such case, this brother, what he did, he had a knife with him, X's brother, and he gave stabbed Gopal in the chest. He stabbed Gopal. Suddenly, he took out a knife and stabbed Gopal in the chest, and Gopal dies at the spot. High Court acquitted father but not son. High Court said father is not guilty but son is guilty. Supreme Court acquitted son too. Supreme Court said even son is not guilty because he has a right to private defense extending to death when there is an assault with intention of kidnapping or abduction. When there is threat of kidnapping, when X, his sister, is being kidnapped by her husband against her will, then this is a case of abduction. and Gopal was trying to abduct his wife against her will. And in this case, right to private defense extends to killing as well. So he killed. Okay. Although this is not a good case law, it is a controversial observation. Okay, anyhow, but what Supreme Court has stated, it has stated. Okay, but otherwise, as per what I feel, definitely because Gopal was her husband and would have taken her to with him only. They could have definitely called the police later, and police could have went to the Gopal. It is not a case of kidnapping in which some stranger is kidnapping someone and you do not know where this person will take you. You understand the difference. A stranger is kidnapping you. A small child is walking on the road. Some stranger comes on the bike, tries to kidnap the boy. And in order to save the boy, I kill a man. That is a different case because he is a complete stranger. We do not know what will they do with the kid later on, where they will take him. But Gopal is the husband of X. He is taking her wife. Even if he abducts her, even if he abducts her, definitely he will take her somewhere where he is living. And because he is now their relative, they definitely know where Gopal is living. Okay, so they could have definitely gone to the court, gone to the police that Gopal has kidnapped X, and police would have assisted them. But they stabbed him and they killed him, and they used this particular right. So Supreme Court agreed with it, but it is quite controversial. Okay, anyhow, what Supreme Court has stated, we are reading. I have given my observation as well. Amjad Khan versus State. Communal riots were there between Sindhi refugees and local Muslims. Okay, there were communal riots between Sindhi refugees and local Muslims. Muslim shops were looted and lives were lost. Okay, mob approached the shop of accused. Now Amjad Khan is a Muslim. He is a shop owner. Okay, and in that, look at the background. What is the background of situation? There are communal riots. Some Muslim shops were looted and some Muslim people were killed. Now a mob is approaching a shop of accused. Accused is Amjad Khan. He is a Muslim. His home was also behind his shop. Okay, he's having a home, and inside his home only he's having a shop. People started beating the doors of house with sticks. Okay, they are having lathis, they are sticks, they are beating the house that come out, will kill you. Before mob could break in, the accused fired two shots from his gun. Okay, before mob could enter his house, he fired two shots from his gun and two people died. Supreme Court allowed the appeal means acquitted him, and said it was sufficient to afford the right to private defense. Accused had reasonable ground, death or grievous hurt to family, many lives were already lost. Supreme Court said that if we view all this in the background, that communal riots were there, so many Muslims had already been killed, and Amjad Khan being Muslim and a mob is approaching his house with lathis, and his house, he and his family is living. So there is definitely an imminent threat of loss of life to him and his family. And in that situation, if Amjad Khan shot people dead, then he has committed no offense at all. So Supreme Court acquitted Amjad Khan. This could be a perfect case of how our private defense is justifiably and reasonably utilized. Okay, this is a justifiable and reasonable use of right to private defense. Okay. Now we are done with our basic of the criminal law. What is a crime? What are the theories of punishment? How a crime is committed? What are the ingredients of the crime? And what are the exceptions to a crime? What if a crime is committed? What are exceptions to such crime? Now we'll go to offenses. What are the offenses? Okay, offenses are distributed in different parts in Indian Penal Code. First part is which deals with offenses against human body. Okay, firstly, it begins with offenses against human body. What could be the offenses against human body? Okay, first, let us understand negligence as a criminal category and its juristic interpretation. Now, we read negligence in the tort law. Okay, we read negligence in law of tort. What is negligence? Negligence means a careless and reckless attitude without consideration to the outcome. A careless or reckless attitude where you are not worried about the outcomes, where you are not worried about the outcomes. Okay, or may say, but are confident that nothing wrong would happen. It is a careless or reckless attitude without consideration to the outcome, or we may also say it is a careless or reckless attitude where we have a knowledge about possible outcomes. We have knowledge that due to our reckless attitude, this may happen, but we are confident that nothing would happen and we would handle it. Like the case of rash driving. Okay, when someone is driving rashly or when someone is overspeeding. Okay, in your age, sometimes you people are riding your cycle on very high speeds, or some people have also started using underage people. So many times, parents, because you people are in school, so many times parents have been seen that they are giving scooties, okay, to their children. Scooties to their children. You cannot find a more deadly combination. Okay, a child and a vehicle and a motor vehicle. There is no more deadly combination than this. But parents are confident, and even the child is confident, and now ultimately the whole society has become confident because it's a kind of trend that yes, children will not do anything, they'll just use the scooty to go to the tuition or go to the school or return from here, there, and that. Okay, but ultimately it is a very deadly combination, but because people become negligent, okay, people feel nothing wrong would happen. Okay, and someday ultimately some accident happens. There is some loss to someone else, or there is a loss of the child itself. Okay, then this kind of case fall in the category of negligence, recklessness, or carelessness. Okay, when we are too much careless about the outcome, or we are aware what could happen, but we keep on ignoring it, or we are too confident. Or let's take the case of adults when they have a license to drive. Okay, me suppose like me and so many other adults, sometimes we are over speeding. Okay, we are over speeding or we are jumping the red lights. Okay, we should not do it, nobody should do it, but we are aware that we should not do it. But when we are doing it, okay, when we are over speeding or when we are jumping the red light, usually we people are confident that nothing would happen. I will jump the red light easily and nobody will come in between. Or when I am over speeding, I am confident that if something wrong happens, I'll apply the brakes, I'll handle it. Okay, and ultimately someday accident may happen. And it may result to injury to someone, even to death, to myself as well as to others. So these are the situations which are covered by the term negligence, that we become too negligent to realize that something wrong can happen. This is called negligence. Now, negligence also has become a kind of crime. Not a kind of crime, but definitely we have given negligence a criminal category in the Indian Penal Code. If we go back to the basics of the criminal law, okay, first class in which you read ingredients. Ingredients of crime. We discussed mens rea plus actus rea. That means a guilty act and a guilty mind. Okay, now guilty mind and guilty act both must come at the same point of time. Now, guilty mind means you are doing something with the knowledge. Okay, guilty mind means you are doing something with the knowledge, with the intention to do something. You are committing a crime with the intention of committing a crime. But in negligence, do we see the intention? I mean, is negligence an intention? Can there be an intention in negligence? When I'm driving fast, okay, or when a parent is giving the scooty to his underage kid, 14, 15-year-old kid, and the parents have given a scooty to the kid. But my parents have gifted me a car just because I am an adult and I am over speeding and I meet an accident or the kid meets an accident. Did I want to meet an accident or did parent want that kid should meet an accident? Did they do it with an intention? Definitely not. Neither in my case nor in the case of parents. Neither me driving would ever have an intention to meeting an accident. Nobody would like to meet an accident. Neither parent or neither child would like to meet an accident on the scooty. Okay, but it happens. Sometimes it may happen. It's an accident. So where is mens rea? Mens rea is guilty mind, isn't it? That you should have a guilty intention. Negligence is that you are unaware. Guilty mind means awareness. Guilty mind automatically means awareness that you should be aware what you are doing. But negligence means you are not aware what may happen. Okay. So, but negligence is treated as a special case. Okay, it's being treated as a special case. Okay, though there is actually no mens rea. Okay, there is no guilty intention here to commit an accident or with a rash act to hurt someone, but law says you were so careless in your actions that you should have had knowledge that it could result into harm. And your lack of knowledge or lack of consideration to the knowledge of facts is just like a guilty mind. It itself is a guilty mind that you are guilty. Your mind is guilty because your mind ignored a conscious fact that something wrong may happen. That is why we have negligence, okay, or rashness as part of criminal liability as well. We have it in the law of torts, okay, as well as we have it here in the criminal part as well. Section 304A is the section which deals with the negligence part. Death of a person by rash or negligent act, not amounting to culpable homicide, punishable for a term up to 2 years, fine, both. Okay. This term homicide, okay, is made of two words, homi and side. Homi means homo sapiens, means humans. Side means killing. That is why we have suicide. Su means self, side means killing. You kill yourself, that is suicide. Homicide means you kill another human being. Okay, culpable means guilty. Okay, guilty. So, culpable homicide means guilty of killing other. Culpable homicide means killing of another human, guilty of killing of another human. So, death of a person by rash or negligent act, not amounting to culpable homicide, punishable for a term up to 2 years, fine with both. Okay, the law says death of a person, if done by rash or negligent act, it will not amount to culpable homicide. Okay, it will not be similar like killing a person. Okay, someone has drove his car in such a manner that it has met an accident and some people have died. But definitely he is negligent. Okay, but obviously he is negligent in driving, but definitely he never intended to kill other person. So we cannot keep him at par. We cannot keep this negligent man at par with someone who's consciously killing someone. Okay, who's consciously having a mens rea to kill someone and acts as well in order to kill someone. Okay, he's having a mental planning and then action. Here, action is happening out of carelessness, and mens rea is not present at all. So, we treat this case specifically different from guilty of killing another people. That is why only 2 years fine or punishment. Okay. Criminal rashness is a hazardous act with the knowledge that it may cause injury, but without any intention to cause. Okay, just like we discussed, you know that your action could cause some injury, but you do not have any intention to cause so. Negligence is the omission to do something which a reasonable man would do, or something which a reasonable man would not to do. Okay, negligence is also just like a rashness. You are supposed to do something, you did not do it. Okay, you were not supposed to do something and you do it. You are not supposed to drive high speed, you are driving it. You are not supposed to give scooty to the kids, you are giving it. Okay, or you are supposed to follow a red light, you are not following it. Okay, so criminal rashness and negligence, they are somehow similar. Both means a part of carelessness on your part. Okay, which has now difficult repercussions. Cherubin Grogri versus State of Bihar. When people started using the accused washroom. Okay, now this is a old case of 1964. That time when India did not have washroom coverage everywhere. Okay, even till 2000, early 2000s, we also all the villages did not have washrooms. Okay, so this is 1964. You can understand washroom could be very rare. Okay, people did not have washroom. They used to use open fields. So in this case, this Cherubin Gregory, he is a Britisher. He remained in India. Some Britishers left, some Britishers remained. So he must be having a washroom, okay, in his house. When people started using the accused washroom, now the people are illegally using his washroom. Definitely that fact is going to irritate him. Nobody likes that somebody else, and that to so many people of general public in numbers come and use your washroom. Accused made it clear to them that he did not want them to use it. Accused cleared that I do not want you to use it. He fixed live wire inside without any message. He put a live wire inside the washroom without putting any warning sign. He did not place any warning sign at all. Deceased continued to use the washroom carefully without touching the wire. Okay. Now deceased continued to use the washroom carefully without touching the wire. The deceased means person who died. Person who died. Okay. She continued to use the washroom. Okay, without touching the live wire. One day she accidentally touched it, and the voltage was so high that she died almost instantly. Okay, one day she touched it and she died. It was held that charging such high level of voltage was a rash act done in reckless disregard of consequences, convicted under Section 304A. This person was convicted under Section 304A, causing death by rash and negligent act. This person claimed that I was trying to protect my property and it is a right to private defense. Court held that your right to private defense cannot be extended to such case to cause someone's death merely because someone is using your washroom. You could have put a lock, you could have put a door, you could have done so many other things, but you chose to put a live wire. But he was not held guilty for culpable homicide because deceased was aware. Okay, if the deceased was not aware and she would have died, definitely he would have been in a serious trouble. Okay, but because deceased knew and she carefully never touched it, but one day accidentally she touched it and died. That means there was some portion, culpable portion from deceased as well. That is why he was charged only in section 304A. Otherwise, his case would have definitely gone into some other section, more serious sections. In this section, the maximum punishment is only 2 years. Otherwise, it could extend to 10 years and up to life imprisonment and ultimately up to the execution of a person. Dr. Suresh Gupta versus State of NCT 2004. Okay. The appellant, who is a doctor, plastic surgeon. Okay, this appellant is a doctor and plastic surgeon. This case is a case of a medical negligence. This is a case of medical negligence. Nowadays, we see a lot of cases on TV and newspaper that some surgeon conducted a surgery and he left the hanky inside, or he left a wristwatch inside, okay, or left some other surgical instrument inside the abdomen and sealed it, and then had to conduct another surgery, or this and that cases. Okay, we have heard these cases. Okay, that's a doctor was supposed to amputate right leg, and in place of right leg he amputated left leg. Okay, now he has detached the leg which was not supposed to be detached. Okay, has cut short that limb. Now whatever limb is left, it was also supposed to be chopped off, or amputated is the proper legal term. Now they are going to amputate this leg which is left. Now the person is footless. Okay, why? What is that? This is called a medical negligence. Now, if someone is faced with a case of medical negligence, what a medical negligence is and how you have to identify a medical negligence with a case of normal negligence or rash negligence. Okay, let us read the case. The appellant is a doctor, he is a plastic surgeon. In in his dock as an accused under section 304. Is in the dock. Is in the dock means he is charged as an accused under section 304A. Under 304A for causing death of his patient. Now, this doctor who is a plastic surgeon, he did something due to which some patient died. From the medical opinions produced by the prosecution. Now, prosecution is the one who is leading a prosecution against him. Means state. Prosecution means state or police. Okay, which has filed a case against him. They brought some medical opinion. Okay, they brought some medical opinion from other doctors. Okay, they got medical opinion from other doctors over the surgery which this doctor had conducted. The case of death is stated to be not introducing a tube of proper size as to prevent aspiration of blood from the wound in respiratory passage. Now there is a wound in the respiratory passage. Okay, maybe probably somewhere in chest or the neck region there was a wound, and the medical opinion suggested that doctor should have used a tube of proper size to prevent aspiration of blood. Okay, this act attributed to the doctor, even if accepted to be true. Now, Supreme Court says if we accept the medical opinion to be true, that doctor should have put a tube inside the patient's chest or inside patient's neck region in order to stop the aspiration of blood. Okay, even if we accept that he failed in doing so, can be described as negligent act as there was lack of due care and caution. Okay, that this act can be described as negligent act. We can say this is a negligent act. Okay, we cannot call it a case of killing someone. We cannot call it a case of culpable homicide. We can purely call it that he was negligent and he lacked proper care. For this act of negligence, he may be liable in the tort, but this carelessness or want of due attention skill cannot be described to be so reckless or grossly negligent as to make him criminally liable. Okay, Supreme Court said that this act may be definitely negligent, but this particular negligence he can be proceeded against in the civil cases of tort. Okay, that is compensation may be sought from him. But in criminal case, because someone is put behind the bars, we require a higher degree of negligence. Okay, but for this negligence, we cannot make him criminally liable. Supreme Court stated. Okay, to convict, therefore, a doctor. Now, what is required to prove in a case of medical negligence? Now, Supreme Court says to convict a doctor. To convict, therefore, a doctor, the prosecution has to come out with a case of high degree of negligence in part of doctor. It is required that there should be a high degree of negligence from the doctor. Okay, mere negligence or small negligence on the part of doctor will not make him criminally liable. Okay, there has to be high degree of negligence from a doctor. Mere lack of proper care, precaution, and attention or inadvertence might create civil liability but not a criminal one. Doctor Supreme Court says that doctors are daily performing numbers of surgery, almost thousands of the surgery across India or lakhs of the surgeries across the world every day. Okay, and surgery is such a minute thing that it may happen that sometime a person may die. Sometime a person may die, and when he dies, it may come out to the knowledge that some tube may not be put in the place, or there was ICU was not proper functioning, or this and that. Okay, but because doctors are performing so many surgeries, okay, if we start making them criminally liable, ultimately all the doctors will be behind the bars. Okay, ultimately all the doctors will be behind the bars because sometimes there may be issues with the surgeries and sometimes there may be not, and it all depends upon the condition of the patient as well. Sometimes the condition of the patient may be so worse that all the proper care and caution may not save him. So in such cases, in all those cases, if we are going to run against the doctor and chase him and put him behind the bars, so ultimately we will one day put all the hospital behind the bars. Therefore, no case of reckless or gross negligence can be made out under section 304A. Supreme Court said that under 304A, doctor cannot be held liable for criminal actions for killing someone by death and rash act just because he forgot or he did not take some proper precaution. There has to be some high degree of negligence against the doctor. Now, this is what Supreme Court is saying. Okay, and we are bound by the Supreme Court. But ultimately, what is high degree of negligence? Okay, Supreme Court failed to define what is the high degree of negligence. I mean, a person has died, and Supreme Court is saying that there should have been high degree of negligence. Now, what is a high degree of negligence? What can be a higher degree of negligence than the one which result into death of someone? Okay, so this is what Supreme Court is saying, but ultimately we are bound by the dictum of the Supreme Court. But definitely, as a student of law, okay, and as researchers of law, we can definitely criticize a judgment which, as per our conscience, is not fit. Okay, in this case, definitely, if the doctor forgot to put a tube in the respiratory passage and person died, this is squarely a case of death by negligence of a doctor. It is a case of medical negligence, and doctor should have been held guilty. Okay, we cannot leave a doctor just because he is a doctor and someone has died. Okay, so I do not agree with the judgment, but yes, we have to follow it, and this is how cases are decided in the criminal law. This is the negligence in the criminal law, and next we will begin with the murder and other big crimes. Thank you.